speaking. With me, Tarun Nagia. Today is a special Saturdays with Singhvi show, and this show will have a global audience. So I have to give an introduction of Dr. Abhishek Manu Singhvi. We all know he's an eminent jurist. He served as the chairman of the Parliament Standing Committee on Commerce, Law, and Home Affairs. As you all know, this is his fourth term as a sitting member of parliament in the Rajya Sabha, currently serving his fourth term. Also, he is a member of the Congress Working Committee, which is the apex body of the Congress Party, which is one of the nation's oldest political party. He many years ago served also as the additional Solicitor General for India. Uh, he also currently serves as a national spokesperson of the Indian National Congress. And he's recently, of course, we saw that very big program that he organized as in his capacity as the current sitting chairman of the Law, Human Rights, and the Right to Information Department of the Congress Party. Uh, and more than that, he's one of India's leading counsels at the Supreme Court of India, uh, whose every word is reported, discussed, and debated all across the country, many times in different capitals, given that he argues equally in constitutional matters as well as the top corporate matters on a day-to-day basis. Good to see you, and thank you for your time. Today we require, yeah.
Thank you so much for a very generous introduction.
Certainly.
Is that though it was very nice to hear that, I, of course, have multiple hats. That's the joy of my life and the bane of my life, multitasking. But I really, above all, come here for this particular program as a student of law, as a practitioner, as a person who has spent almost a lifetime in this ecosystem, despite my multiple hats.
Thank you, thank you. And I humbly put it as you would always do. But today we require and request your indulgence to speak on the incoming Chief Justice of India, somebody who grew ground up. He's a self-made man, rose from a lawyer, then Advocate General, of course, a judge of the Punjab Haryana High Court, Chief Justice of Himachal, and now the Chief Justice of India to be designate Justice Suryakant. This is our flagship series titled Justice Suryakant, the Chief Justice of India, Opportunities and Suggestions. And may I request you that what would be your opening few comments on opportunities that he has, because he has a long tenure. 16 months is a long time to execute a lot of the vision that he may have, or in a sense, make good change to the system. What would you sort of talk on this?
Tarun, just before I come immediately to the longer term suggestions, let's just look for a couple of minutes at Suryakant, judge, human being, person, etc. Obviously, he has not been in the Supreme Court that long, and I practice mainly here, but we have all seen him in the bar as a very, very young advocate general. Don't forget, he was one of the youngest advocate generals in his days. And I have seen him, of course, in action as a judge. And what you said, the bottom-up life which he has had, that makes a person's personality, and therefore his grassroots awareness, his awareness of realities, his awareness of nitty-gritty in a district court or a mufassil court, his awareness of the fact that all the sermons you give, all the rhetoric you make, can fail easily at the anvil of a particular reality in every district court in India or in a particular mufassil court in some part of India. I think that is what he has brought out frequently in his adjudicatory processes, and that creates a remedial situation which is real, which bites at the ground and cures the problem. He doesn't give an airy-fairy solution which may have no relevance to the ground reality. He's had, of course, diversity, being an advocate general and then being in two different high courts makes a lot of difference. So a diversity of experience, and linked to the first point, of course, pragmatism flows. If you've risen from the bottom up, pragmatism is uppermost. You are not here ultimately to lay down the law only, or to lay down the law substantially and forget the reality, forget the healing touch, forget the remedy, forget the solution. So I think it's a great time for him. Just under a year and a half is, by Indian standards, a very significant tenure in the Supreme Court. It wouldn't be called significant in some other countries, but it's a good time to be able to do good work. He's a sharp, quick mind. He's a very courteous person. His interpersonal relations are very, very soft and accommodative. And these positions require, with this good tenure, they require an ability to carry people along with you, as all leaders have to. And the Chief Justice is a leader of a team. You can't do it just by yourself. And I think that overarching, non consensual, unilateral, singular approach is not ever what uh, Justice Suryakant has practiced. So I expect that he'll be able to carry on one side the bar, on the other side his colleagues, and in fact on a third side, high courts and lower courts in all reform movements. So it's a good, propitious mix of qualities. Of course, the future will decide how he's able to utilize them, but I have great hopes and great expectations.
In fact, we sit currently on about 6 crore pendency of cases. In Supreme Court, it's touching 90,000. And of course, there are many other areas. I mean, there are issues like mentioning, there are also issues of infrastructure all across the country. As the chief of the judiciary, he'll also be looking at the infrastructural issues. But there is the advent of artificial intelligence, which he has publicly spoken on. All of that. Any suggestions that 4, 5 of them which you would like to sort of share with him? Uh,
Yes.
these
Uh,
all these subjects.
Yes. So before turning to his more particular pet theme in the current context, let us discuss those general suggestions, which I've had the privilege of some of them making with you earlier. Some have been done, some have not been done, some are in the pipeline. But I want to just be very quick and pointed on this. First and foremost, and you might consider it my pet peeve, is something which I must repeat. Time has come, maybe not publicly declare, but certainly internally, at least 5 subsequent incoming Chief Justices, including this one, should internally have a 10-year plan. What I called in your earlier program, uh, something like a political common minimum program. Now, as I always say, a common minimum program starts with the assumption that we agree to disagree. So there are 10 issues on which you and I don't agree. There are 20 issues on which you and I don't agree. And you don't have to agree. There are always, with some effort, consensus able to be reached on 5, 7 core issues. And they are structural. And I'm not now going to which one is better. I may think X is better, you may think Y is better. Justice Suryakant may think Z is better, another judge may think A is better. That's not the point at all. You have to have this conversation with the next 5 Chief Justices and make this CMP on 10 core issues. And one of the biggest bugbears of the Indian system, Tarun, is this constant zigzag, this constant lack of continuity, this constant need for me to put my stamp over you because I have come and you have gone. That can be taken care of significantly by this consensus on these 7, 8, 10 issues. And they should include, um, because they are structural issues, a kind of a protocol or a standard operating procedure. For example, I'm giving again an itemized illustrative list of these 10 CMP issues. They can be different, I don't care, they can be the same, but they must be there. There is no continuity today. For example, they can agree that in the collegium system for appointments, which is another problem in the system, delayed appointments, pending with the High Court collegium, then the Supreme Court collegium, then most above all with the central government, sending back, not appointing. On this, why can't they agree that, look, if it happens too many times that you send back a second time and the government still delays, we're going to issue a notice of contempt, maybe to the law secretary. And I'm not talking of political A or political B, but I'm talking of a system. Maybe if that is not enough, then to the law minister. I have no doubt, I've said so many times, that if this scourge of insisting on a government appointment despite 2 referrals back happens, then one single notice of contempt will stop it. But they've not done it till now. A second area of a CMP would be a stipulation internally, very clear, down 5 Chief Justices, which takes you to somewhere like 2032, 2034. that you, the Collegium Supreme Court, will take X and no more than X weeks to decide. Again, I'm not bothered about whether X is 1 week, 2 weeks, 20 weeks. And you, the Collegium, will then work on the High Court to ensure with all Chief Justices at the Chief Justice Conference that they will not take more than Y weeks to decide. And then you will ensure that the system works in tandem with that SOP. A third area is infrastructure. And I don't like this thing of talking of the Supreme Court too much. Supreme Court is an island, as most parts of India. It's in India within an India. You have to talk here of the lowest rung, the district judiciary, which includes the lower than district judiciary also. On the ground, you have this very strange spectacle. What to talk of district judiciary, even the High Court, that where you have a full complement of appointments, which you've never reached, but when you have a substantial complement of appointments, you don't have courtrooms. In district courts, it's happening all the time. If you have courtrooms, you don't have facilities. A courtroom is not just a courtroom. You can even use a security man's room as a courtroom temporarily. That doesn't mean that you have a antechamber for the clerk, a library room, etc. So you have now the reality of India that a lot of district courts, even with judges, have no place to work, no operational reality. VCs don't work routinely. Just having a VC and a computer is not operational in terms of an efficacious use. And here I know the law. The law is that you don't, as a Supreme Court judge, have direct administrative power over the district courts. You don't even have it over the high courts. And administration, you as the High Court judge is the boss. The Chief Justice is the boss. But you have in the Supreme Court a lot of moral power, a power to catalyze, a power to lead, a power to exhort, a power to push. And I have no doubt that they should take a lead on that in their CMP. They must also, in the CMP, put down very specific criteria, as specific as can be, about this nonsense of poor human material getting through the tribunalization of justice. The tribunalization of justice has occurred now. It's a given. It's been going on for 30 years in our country. But it has not served any of the purposes intended to be served by tribunals. They were supposed to unclog your clogged arteries because you are the court. So ABCD, access, backlog, cost, and delay. Today, entirely because of the poor human material you find, sinecures, post-retirement sinecures, you are acting as an employment exchange with poor human material. And some of these are top tribunals with huge, humongous jurisdiction. I will not take names. I happen to be privileged in that I appear, apart from Supreme Court and High Courts, in tribunals. Be sad and distressed at the majority of the human material I encounter. This is not to say that you don't have great islands of excellence, which is why the system is at all up and about. But that is where, in each of these tribunals, Tarun, you as a Supreme Court judge are selecting. Your nominee is selecting. So you have to take responsibility. And there must be a set of criteria which 5 Chief Justices will insist upon through their nominee. You'll find a change. If the government wants to do a deal, sorry, no. This man has to be of this quality minimum. If the nominee judge has different views, sorry, no. The criteria are these. Then again in the common minimum program, do something new. Chief Justice Khanna, for example, managed, he realized he has 6 months or whatever, 7 months or 5 months. Justice Suryakant has longer time. He can choose a subject. I'm only giving examples. I'm not concerned about what he chooses. He chose NMDs, non-miscellaneous pay cases. He hyped off a chunk of them by disposal. You may complain that he took excessive interest and priority, but he decided that let's attack at least one thing in his short time available. Justice Suryakant can choose his category. Take, for example, 3 categories I love to talk about. Let's say all cases in Supreme Court above 10 years. Put a day only for them. And on that day, you'll not hear miscellaneous. At least, let us say 15 courts or whatever courts are doing above 10 years. The scourge of your system, the thing which brings you a bad name, is a 15-year plus case in the Supreme Court. Why is it there? Because it's not tracked. If it's tracked, it is infructuous and we finish in 2 minutes. So tackle that. And this is all to be done by screening. Bright youngsters with a technical background don't need a legal background for it. Must do screening and put it up to you as a Chief Justice. A healing touch, for example, something I said in Justice Gawai's program, for people above 65, where one party at least is above 65, corporates have to be excluded. Imagine the healing touch for the number of, and the number of cases involving above 65 may not be very large in the Supreme Court. It's larger down in the lower levels. But finish them off. I mean, he will give you a blessing, one way or the other, one will lose, one will win. But I mean, imagine the pendency of a man above 65 already and then going on to 90. And then another category you can pick up. And here I think Justice Suryakant has special expertise. The more rural, genuine rural. See, now India's no more rural in that sense. We have more urban, which is a mixture of urban and rural. But still there are, where some parties have rural grievances, agricultural matters, land acquisition matters, etc. Again, a category which is a very nice category to pick up and dispose of, because there are not many, at least in the Supreme Court level. Like this, you can have 5-7 categories and you will actually leave a mark. Nobody can clear everything, but we know you are there for 18 months. You know that these 4-5 are crying out for attention categories. Attack them and focus on them. And also, lastly, on the general part, before I come to his more particular favorite themes, the fact that you have this zigzag, which I'm very disturbed about this miscellaneous one day, NMD on another day, so far so good. But then regulars must be disciplined and stuck to on Wednesdays and Thursdays. We had a period when zealously Wednesdays and Thursdays were only for regulars. Then we had a change where a lot of miscellaneous or NMDs also started coming on Wednesdays and Thursdays. So you never reached the regulars. Somewhere you have to say no. I mean, it's not that the other cases are not important, but you have to put your foot down and say on Wednesday and Thursday, if you put regulars, you put only regulars and you can't put non-regulars. Now, my problem is not that policy. My problem is the zigzag in that policy. Sometimes you had one policy, sometimes so neither. If you keep zigzagging, then no policy, by the time it has a synergical impact, is already changed. And I would also oppose this multiple list system. Today, there is a system in the Supreme Court that all judges, lawyers are all caught by surprise. Matters come suddenly, late evening. Just have two simple lists, a weekly list and a daily list, and then stick to it. And nothing which is not there, unless there is super emergent, like your house is being demolished tonight. Those are different categories of cases. Somebody is being executed tomorrow night. Barring that, you will stick to the list and not leapfrog the list. And the list will be one weekly list and one daily list. Today, it's not happening. It creates a huge confusion. There are, of course, so many other things, but I'm just saying these are issues on which you have a CMP and start the same system over 5 Chief Justices. Don't change it mid-course. Don't try and leave your stamp or the next Chief Justice stamp or the next one on these. The rest you can change and do what you like.
Now, on issues like artificial intelligence, on issues which are, in a sense, taking the judiciary to the next level of technological leap. Uh, any reflections, or because you see this on a day-to-day basis, any reflections or suggestions on that?
See, this is something which has come to stay. There is no question of the if question anymore. It's all a question of how and how well. It's neither if nor when nor what. One level of this argument is at the technological level, where neither you have control, nor I have control, nor Justice Suryakant has control, nor the Supreme Court has control. Technology may make Chat GPT much more efficacious. It may make perplexity effective. Now you have people coming to me and selling some legal programs which can prepare your case in a jiffy, give you an arguing note. There are people who are doing that. Now the point is, this is the march of technology which we must keep abreast with. Point number one on your AI question. We must keep abreast. We must be open and positive towards it. We must not be xenophobic about it. We must not be resistant to it. But the second point is we must always be there to be the master and not forget slave, but not even the equal of it. We have to be its master. And let me tell you, so long as you're a master, you'll always control and be aware of the distortions. So you can control it. But don't always talk about the fear of it, the distortions which are inevitable, as a means to not assimilate it fully in your system. I think in these matters, Justice Suryakant realizes, from what I see and hear, the, that the right approach is this. And inevitably, you will find it working everywhere. Now, slowly, lawyers are going to use it, judges are using it, registry will use it. So he has to harness it. But again, my problem is not with the Supreme Court. You are talking about an island. You just mentioned 80,000. 80,000, nothing. It's something which, जिसको हिंदी में कहते हैं ऊँट के मुंह में जीरा भी नहीं है. Under our noses, while we are doing seminars, discussions, I'm probably written more or spoken more on this subject than any other subject. Reforms in the administration of justice, beating the backlog. Under our noses, from 3 crores, we have come to over 5 crores. I won't say 6, it's well over 5 crores. Pendency, of which the Supreme Court is an insignificant island. But it has happened while we are talking about area reduction. We first had the ready, handy excuse of COVID. It's nothing but a fig leaf. See, I'm very blunt and candid about my. It's gone, not only long gone, it has now increased with no necessary connection with COVID. So there is something wrong with what we are doing, no? If we are talking under our noses, a 3 crore is heading towards 6 crores. This is the last 5 years. This is a serious issue, and ultimately this will engulf us, overwhelm us, which is what brings me now to, this is directly linked to what is rightly Justice Suryakant's pet theme in the last few weeks or months before he takes over on Monday. And that is mediation. It is now very clear that it's a matter of detail whether you call it 5.5 or 6. It is very clear that you cannot clear 5.5 crore cases by adjudication. Let us be very clear. The dialectics of adjudication is I propound a thesis, you do an antithesis, the judge gives a synthesis on top. That's the adversarial system. It necessarily is adversarial, it necessarily takes time, and above all, after the synthesis, there are 2 more syntheses at 2 more levels, minimum, sometimes 3 levels, appeals. There is no way in which 5.5 crores can be cleared by this approach. In not many lifetimes, but at the end of the era. So we need, what he's rightly saying, to unclog it in mass numbers, in collective numbers, unclog the arteries and subject them to ADR, which is non-adjudicatory, which is non-adversarial. At the end of the day, it is, by, of course, theoretically it is consensus, but you need head banging to come to the consensus. Consensus doesn't happen otherwise. So if you can do even half the success rate of Lok Adalats, so in number terms, 2 things have to work together. Lok Adalat, which works in the smaller matters, it has a limitation. It works for motor vehicle accident claims, it works for land acquisition compensation claims, and a few other categories. Along with that, you have mediation in other categories. These 2, the numbers in Lok Adalat are very impressive, some 20 odd crores over the last decades, several decades. Now you have to achieve those figures in mediation. And fortunately, we have a state-of-the-art statute. I had the privilege of speaking on that statute in the Mecca of mediation, Pepperdine University in California. And they were amazed at the absolute newest thing we have in 2020. It's a question of operationalizing it. And a man like a Chief Justice of India, Justice Suryakant, takes it up. It will get it the impetus, it will get it the push. And at the end, to end this point, it doesn't need much. It needs a consolidation. We already have the structure. It's now consolidation. For that, it needs a very good set of mediators. That's in numbers, not only in quality, but in numbers. We don't have enough. You may theoretically have mediation centers with all courts attached, but you don't have competent people, enough people there to handle it with the numbers we want. We don't want a few thousand and few lakh mediations. Yes, Justice Suryakant, I'm sure, is thinking of crores, which is what this Lok Adalat achieved. So for that, we need human material, and I can get 2 crore mediators tomorrow, but you can't just pluck them out like that. They have to have some quality, integrity. They have to have so that takes time. Second thing is a culture where judges actively help mediation. Ultimately, the first port of call is Justice Nangia's court. So he has to somehow, and it's not easy. Egos are overarching, fights are serious. So he has to push it to mediation and then track it, that it comes back to him within a time-bound schedule. And there has to be some push, some threat, some implied threat, some help, some persuasion, call it what you will. If this culture gets to the high courts and the district courts, it will not be Justice Suryakant's success if he manages the Supreme Court, which is again an island. But it will be success because as an exhorter, as an icon, as a leader, as a catalyst, he gets that culture working in the 2 lower levels. And that is, I think, what he has in mind. And I wish him good luck on that.
Now we come to the final, what you can say, question of the show typed on Justice Suryakant as CGI opportunities and suggestions. Any good wishes for Justice Suryakant? I think it is one needs, in addition to hard work, a lot of luck to be the chief of the judiciary of the country with the world's largest population. He's the Chief Justice of India.
Great privilege.
And any good wishes for him as we end the show?
Well, all these are good wishes. We don't want to overburden his already overflowing plate. He's already obviously a man with multiple roles and multiple. So you don't want to, keep on. But these suggestions, if a part of them are started and fulfilled, and just to pluck out a few of the general ones and the mediation one, will change the whole, identity and profile of the litigation system and above all the areas. It's the scourge of areas we have to deal with. And if you combine it with the CMP, you will leave a mark. Don't think that I started it, but Nangia got the credit. Don't think that Nangia started it, but the third person got the credit. All 5 will get credit if they push with the same pace and keep their foot on the accelerator with the same degree of interest. If the interest wanes, 18 months is going to be nothing.
Okay. One final line message for Justice Suryakant's tenure as a good wish for his.
Choose 4 or 5 areas, be selective, and then go after those areas because you will have results to show. Don't bite more than you can chew.
Okay. Thank you. Put it very succinctly. Appreciate your time and on Saturdays with Singhvi, where you spoke about Justice Suryakant, opportunities and suggestions. Indeed, some very thoughtful. Hope some push on mediation, which you suggested, some on AI and some other topics. As usual, it was a pleasure to talk to you, and look forward to see you again on Saturdays with Singhvi. Thank you.
Thank you very much. Thanks a lot, Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.